Today I'm going to talk about corporate governance in relation to MiFID. I'm specialized in company law and property law and liability law, so I will present it from a company law point of view. First, I'm going to give you a very brief introduction about corporate governance as it is seen by the European Union. Secondly, I will talk briefly about the considerations of the European lawmaker. Why did the European Union introduce those new rules in MiFID II? Thirdly, we're going to focus on the relevant articles in MiFID II. And at the end, fourthly, we're going to look for maybe practical solutions. Not very easy because there are so many new rules, but I think also, of course, very important for you. And by the way, we have a question and answer session, but we combine it at the end of the second session of this morning. Well, first of all, if we're talking about corporate governance, we all have a feeling about what corporate governance is. And also national legislators are focusing on corporate governance more and more the last 2 decades. But also the European Union has its own reference. And not everybody knows that, but it's already starting in 2003. But first, what is exactly corporate governance as the European legislator is involved? Well, it defines, of course, relationships between shareholders, management, other stakeholders, and that's, of course, a quite general definition. And moreover, the European Union has a presumption that if we have good corporate governance, at the end, we have a more competitive, a more sustainable, long-term, well-run company. Of course, that's always a presumption, you never know. Sometimes a more chaotic company is also performing quite well in practice, but this is the general presumption. The responsibility for corporate governance, well, first and for all, it's the responsibility of the company itself. That's what the European Union is also saying. And secondly, we have some rules applicable to give guidance to companies. So, by the way, if you look at MiFID II, it's a little bit different because MiFID II is really giving hard rules in relation to corporate governance. So in the beginning, as a start, legislation. There is some legislation applicable. I will focus on that in a few moments. But we also have a lot of so-called soft law, you know that as well. That you need to explain or comply why you are not or why you are complying with certain rules. For example, we see that in a lot of banking codes in national legislation. And moreover, European Union is saying, okay, shareholders, they have a crucial role to play. Especially the more important long-time shareholders should do more maybe than at this moment, like pension funds. So those are the general principles as formulated by the European Union in the past. And they formulated in the action plan of 2012. How did we came so far? Well, it started in 2003 with the modern regulatory framework for company law. It was chaired by Professor Winter. By the way, he's the president of VU University Amsterdam nowadays, so it's quite nice, of course. And they gave a reference, a framework, what corporate governance should be and which issues should be focused on. Well, later on, the European Commission was, of course, taking some more action. They published green papers. Here I give 2 examples, corporate governance in financial institutions and also a corporate governance framework. And also the EP is well, trying to do also some to provide for some new rules. An initiative in 2011. And then in 2012, we have the action plan. And it means now there should be more legislation applicable in the future. Well, if we then look at what actually happened since then, we have some recommendations and some legislation. For example, I mentioned here a few. A recommendation on independent directors. Important ook remuneration, of course. They explain, they give a recommendation. What should be the structure? How should you disclose your policy? There should be a committee which is deciding on the remuneration. And also, there's a recommendation regarding the quality of corporate governance reporting. And especially they're saying it should be very clear, of course, how you report towards especially your investors. And also there, it's the soft law approach, comply or explain. Well, then we have some legislation. That's just starting. We have the Shareholder Right Directive from 2007. There will be a new one, amendments, 2014, a proposal. And again, they focus on long-term shareholders. So again, they hope, and it's really a hope because I think you cannot oblige a long-time shareholder. They hope that long-term shareholders are more active and participate, and especially, for example, pension funds, that if they see something is going wrong, they really go, they involve actively, they approach the board, or they're saying, okay, I'm selling my shares. Well, then we have and now we're coming more in the financial law regulation, of course, the Capital Requirements Directive and the MiFID II. And those two directives are really giving rules regarding corporate governance. So before focusing on the MiFID, one last slide, more general. If you focus on corporate governance, what are the main issues? Well, an issue which is discussed often relates to, do we need to have a one-tier board or a two-tier board? A one-tier board, you have all the supervisory and managing directors in one board. Two-tier board, you have a separate supervisory directors board. In the Netherlands, for example, Dutch law requires banks to have a two-tier board. Unless you have special circumstances, you can have a one-tier board. But the law is saying, okay, you need a two-tier board. I will discuss that later on briefly, why they did it. Well, then secondly, I already mentioned that through the Shareholders Directive, the role and influence on shareholders. That's also always a main issue in corporate governance. I think it's also quite hard to have that in the banking sector. If you have quite active shareholders, I don't see that really happening in practice. The role of employees, also in the MiFID, do they need to have some more influence or not? Maybe even a board position. And then, of course, you always have the stakeholders outside a company. Of course, for financial institutions, that's maybe not such a big issue, but for normal companies, of course, they have financiers, they have banks, and also they have a lot of influence often on those companies because they give them credit and they are quite dependent on credit facilities. And last but not least, prevention of conflicts of interest. How do you deal with that? How is that possible? Should you have supervision in that respect? So all those issues are always of importance if you're talking about corporate governance, so also in relation to corporate governance of banks. And besides that, of course, you have the external supervision. Well, I think here there are also some people from external supervisors, and that's normally a governmental supervisor, but that's not part of what we describe as corporate governance. So then we focus on the MiFID itself. Why are they providing for all those new rules? Well, nowadays they give a lot of considerations. In the past, I think 20 years ago, you get a text of a directive or a regulation and you didn't get too much guidance. But nowadays there's a lot of guidance also from the European legislator. So what are they saying? Well, first of all, there's a presumption that bad governance was a factor to the financial crisis. So the European legislator is saying, okay, we need to be more active in that respect. Secondly, it's a presumption that the management bodies should have more, it seems like that, should have more knowledge, skills and experience to manage such an important institution as an investment firm or bank correctly. So they need to know what kind of risks they are taking and what kind of risks they are not taking. And then we have some interesting things discussed in the considerations, because it also relates a little bit to psychology. They said, well, group thinking should be avoided. I come back to that later, because it's not so easy to avoid it, but that should be avoided. And it's also reflected in the text of the MiFID itself. There should be independent opinions, and in the organization there should be critical challenge. Management bodies should need to be diverse, so not only one group of persons, but a diverse management body. And also they're referring to an employee representation. So sometimes that is also maybe an issue which could be discussed. And then in the consideration, you see a lot of rules which are applicable, should be applicable to the management board. And that's, to be honest, quite some responsibilities. So here the European Union is saying, okay, this is what the board more or less needs to do in a investment firm. So take a brief look. Of course, some parts are quite normal. The strategy, of course, business and risk profile. But some others are more specific. Always the approval of new products. Well, it's not always maybe the case in practice that it happened in the past. Also approval of its internal organization, of course. Strategic objectives. So if you look at this list, you think, okay, it's quite a responsibility for the board nowadays to focus on all those issues, especially if you have maybe a board consisting of 2 persons. And also there need to be a limited number of directorships, because the European Union is saying, okay, you have not enough focus if you have many directorships in many investment firms. Well, that's of course quite logic. About the board structure, the MiFID is saying, okay, you can still choose. So you can choose for a 1-tier or a 2-tier board. It's up to you. We are not going to interfere in that. Also because financial institutions, investment firms have such a wide range of activities nowadays, there need to be new rules applicable to prevent conflicts of interest. Investment firms need to manage those conflicts of interest correctly. And if there is such a conflict of interest, the client needs to be informed correctly, and also the risk should be mitigated. So the European Union, the legislator, is giving a lot of thoughts, ideas in MiFID II, especially in the considerations. So what happened then in the exact text of the MiFID? Well, let's focus on the articles which relate to the management boards, shareholders, the organization as such, and conflict of interest. And later on, a little bit about remuneration. Article 9 is quite important in this respect. What is it saying? Well, it's saying that the CRD is also applicable to all kinds of investment firms. So we have that Capital Requirement Directive, and if you look into the definition, MiFID II is more broad. So MiFID II applies to all investment firms, and the Credit Requirements Directive is focusing more or less, to say it's easy, on the more bigger investment firms. So in Article 9 it's first being stated, okay, Articles 88 and 91 are applicable for all investment firms. So if we're going to look into Article 88 of the Capital Requirements Directive, you see, okay, there need to be a nomination committee composed of members who are not a member of the management board itself. So it needs to be independent, normally the supervisory directors. That's an important thing. We already had it in the CRD. Now it's also applicable to all investment firms. And secondly, also 1891 is applicable. We have 91. And 91 relates to the management board itself. And for example, you need to have sufficient time commitment of all the board members and diversity. So all those rules are also applicable now to all investment firms. If we look further into Article 9, we see that there should also be a segregation of duties. So within the board, there need to be certain members doing this, for example, focusing on employees. Another director should focus on accountants and financial issues, etc. That's important also to have a prevention of conflicts of interest. And then all the issues mentioned in the considerations are also now in the law itself, in the directive itself. So it should define, approve and oversee, and then you see the whole list of what should be defined, approved and oversaw. So I'm not going to mention them all, but again, the remuneration policy, also the firm's strategic objectives, of course, that's quite general, but you need to apply to all those issues mentioned in this article. Competent authorities, focus on them briefly. They must approve members of the management board. In most member states, that's already the case. And also you need to report any change in the board of directors. And a last requirement is that at least 2 persons must manage the investment firm. 2 persons meeting all the requirements. There's a small deviation, and that relates to really small investment firms. Well, so the board, it has a lot of things on their mind. And then we have a second stakeholders, the shareholders. What relates to the shareholders? Well, first they need to be identified if they have a qualifying shareholding in the company. And the competent authority may also refuse authorization if it's not satisfied with the shareholders, the important shareholders of the investment company. So then the competent authority can take action. And if you want to know exactly what the qualifying shareholding is, you also can see it in the MiFID and in the Transparency Directive. So, also in relation to shareholders, there is of course not direct rules applicable. Of course we have the Shareholders Directive coming up, but it's more an overview from the competent authority. Organization. also in relation to the organization, you need to comply to the MiFID II, of course. And then we see the main term is compliance. Of course, many big companies, many banks are already focusing very much on compliance. This is more or less reflecting on that. You need to have a lot of compliance, not only towards your managers, also towards your employees, even to your tied agents. Why should you have so much compliance? Well, administrative and effective organization is quite important. Prevention of conflicts of interest again. You need to take care about operational risks. It may not be too risky. Here again, sound administrative and accounting procedures. We just had a question in that respect. It's also a part of the organization requirements. Record keeping, well, that's of course quite logic. And well, you see a lot of things which need to be focused on and which need to be in conformity with the MiFID II. Then there's a special article related to conflict of interests. You must take all appropriate steps. Well, that's of course quite logic. But also, if you are a big organization, a large organization, it's not always possible to have such an overview. So you need to have control mechanisms. And if something in the organization or in the administration is not sufficient, you need to take action and also disclose it to the client if there is a conflict of interest. And there's also a rule regarding the disclosure. You can see it also in the same Article 23. They are also more or less comparable to those rules, just focused on rules applicable to market operators. And you can find them in Articles 45 till 47. It's all in the materials. So also there, you need to have a broad range of experience in the management board. You need to have sufficient training of members, a nomination committee. It's more or less comparable, but it's good to know that in those articles there are separate rules applicable in that respect. And also you see here in 46 that you must also monitor certain persons who could have influence in the management of the regulated market. Then briefly about the remuneration. It is mentioned in the MiFID II, but it's also in the Capital Requirements Directive. So what is the MiFID II saying? Okay, they're saying, okay, you must define it, approve it, and oversee it. And if you're going to look into the Capital Requirements Directive, we look at Article 92, and then you see for those investment firms, the bigger ones, MiFID II is applicable for all investment firms, but for the bigger ones, you also have some special rules, specific rules related to remuneration. Do not encourage risk-taking, need to be in line with the objectives of the investment firm. Here again, supervisory members or the supervisory board need to overview those rules regarding remuneration. And there should also be a central and independent internal review for compliance. And very importantly, CRD IV is also making a distinction between fixed and variable remuneration. And they're saying, okay, focus on the fixed remuneration, which relates to how many years of experience, what kind of function, and in relation to variable remuneration, it's quite conservative. So do not give too much remuneration in relation to risky behavior. So then in practice, what could we do with this? Well, of course it's quite hard to say because there are so many rules applicable and they also need to be implemented in national law. But you can see already where it's going to a little bit. And certain investment firms are already ready for the new rules, but others maybe need to amend a little bit and need to think about their structure. Because if you look at all those rules, it seems the board must be multitasking. So many things coming to the board, so many things to monitor. And if you're really going to look at large organizations, big organizations, it's always very hard to say what's the most effective and not. So although national legislators or the European Union is looking for clear rules, there's a lot of discussion possible. It also depends at the end of the people, the day-to-day management. People need to comply with rules to be not too risky. So only if the people are doing that, then of course rules are effective. The most important things mentioned before, group thinking must be prevented, create a critical challenge so that there is really different people in the management board or even senior management who can also say a thing, or employees, and prevent too risky behavior. Well, if we look at the diversity and group thinking, it's not a call as such. It should be a critical challenge. And diversity, if you have people from different countries, for example, in the board, it does not always result in preventing group thinking, because also a very diverse group of people can create group thinking. That's more or less the organizational psychology who is saying that. But of course it helps if you have people from certain countries, men, women, different education. It always helps to, if you have someone with an accounting or economics background, a legal background, or really a trader, that's always good to have a diverse group of people into the boards. So the critical challenge is quite important, and it's not always easy to realize, because everybody knows that persons always have their personal interests and also have their own position to defend, to stay, to have your job. So sometimes that's not easy. So how should you deal with that? Well, maybe you should think about having a more extensive board, management board, because then you have more critical challenge, you have more people with different views. For example, someone who's a finance expert, trading experience, maybe even a legal lawyer, which is not always happening, of course, in boards. And of course, you can also think about employee representation, but that's well, that's more or less a thing what European Union is providing for, but it's of course not absolutely necessary, but it could be a solution as well to have someone who is saying what's going on the work floor. Well, in my opinion, and that's more or less also because in the Netherlands we have more or less that rule, I think, but that's of course, you need to be a very, to be honest, you cannot say that right away, but it could be that a supervisory board instead of a one-tier board is more effective. Only as I'm, it could be. It's not really said that that's the way, because a lot of discussion possible also in one-tier boards. It could be good to have a one-tier board because people are really involved in the decision making. But if you look at, for example, why the Dutch legislator wants a supervisory board regarding banks, you have some examples. You have more distance. You have some more independence. And also, if a wrong decision is made, you are not part of that wrong decision making. You are in another board, supervisory board, and maybe you are then able to be more critical. But that's, again, it's not, you cannot say that right away, but because a one-tier board also has great advantages, but it could be that the supervisory board is more critical because of its distance. And you can also think, but that's also, that should be also and more or less a new thing, that you have really employees not being board members, which have a supervisory kind of position. So they have more or less, they're not in the board, of course, so they're not as powerful, but you give those people a lot of power in relation to supervision, and they really need to take care of compliance in a certain department. So that could be also a solution. It always, of course, it happens already, but well, you can think about that and maybe create such positions more formally and designate certain compliance supervisory tasks to certain people in the organization. Then the remuneration policy. Well, we already saw that it's at a CRD IV, the basic, fixed and variable components. You could maybe focus more on basic fixed remuneration. It's already going that way a little bit. Although here again, also a variable remuneration can have positive effects, of course. So maybe you need to find a good balance. You could also think of non-financial positive things. If you reach a certain goal, you can say maybe you can get some external education, or maybe you get free time to do certain other activities. So then it's not only related to the money, but also maybe to other non-financial bonuses.